You said just a short while ago that this COVID presented a grave danger to people in the workplace. In a few minutes, we'll hear an argument in the CMS case, and it will be that it presents a grave danger into Medicare and Medicaid facilities. Not here, but in the lower courts, the federal contractor mandate, the argument's going to be it's a grave danger to federal contractors. Could you give me examples of some federal agencies where you would be willing to say COVID is not a grave danger in that context?
Well, Mr. Chief Justice, I haven't, of course, surveyed the landscape of all of the different authorities that federal agencies can invoke.
But you represent them on a regular basis here, so you have a pretty general idea of some other examples of federal agencies. And my point, obviously, is that I don't think as more and more mandates and more agencies come into place, it's a little hard to accept the idea that this is particularized to this thing, that it's a OSHA regulation, that it's a CMS regulation, that it's a federal contractor regulation. It seems to me that the government is trying to work across the waterfront, and it's just going agency by agency. I mean, this has been referred to, the approach, as a workaround, and I'm wondering what it is you're trying to work around.
What we're trying to do here, and what OSHA did, was rely on its express statutory authority to provide protection to America's workforce from grave dangers like this one. So I take the point and don't dispute that COVID-19 is a danger in many contexts and falls within the jurisdiction of other agencies as well. But I think to suggest that because this disease is so prevalent, because it presents such a widespread harm, somehow OSHA has less power to do anything about it with respect to
No, it's not so much that OSHA has less power. It's that the idea that this is specific to particular agencies really doesn't hold much water when you're picking them off one by one. I think maybe it should be analyzed more broadly, as this is in effect an effort to cover the waterfront. I'm not saying it's a bad thing, but I don't know that we should try to find, okay, what specific thing can we find to say, oh, this is covered by OSHA? What specific thing can we find that say that this is covered by the hospitals? What specific thing can we find to say, oh, no, we're doing this because this is a federal contractor? It seems to me that the more and more mandates that pop up in different agencies, it's fair. I wonder if it's not fair for us to look at the court as a general exercise of power by the federal government, and then ask the questions of, well, why doesn't Congress have a say in this, and why doesn't this be the primary responsibility of the states?
Congress absolutely has a say in this, and it spoke here. It passed the OSH Act and promulgated Section 655C specifically to empower OSHA to take action to protect workers from grave dangers.
When did it do that?
The OSH Act was enacted in 1970, I believe, and the agency, as it explained in the preamble to this rule, documented substantial evidence to show why this constitutes a grave danger.
Well, I don't think you can say that that's specifically addressed to this problem.
Well, Mr. Chief Justice, the court obviously has a statute in front of it that it needs to examine. I think that there is no doubt that COVID-19 constitutes a physically hazardous agent within the meaning of this provision. I think that the immediacy and magnitude of harm here clearly constitutes a grave danger. Unvaccinated workers stand a 1 in 14 chance of being hospitalized, a 1 in 200 chance of dying. The country hasn't seen numbers like that.
It sounds like the sort of thing that states will be responding to or should be, and that Congress should be responding to or should be, rather than agency by agency, the federal government, the executive branch acting alone is responding to. And we're supposed to say, well, yes, this is a CMS problem. Yes, this is an OSHA problem. Yes, this is a federal contractor problem. The military is on its own. They take orders. Again, I guess I'm just repeating myself. It seems to me that we should be looking at it as an across-the-board issue, as opposed to, let's see what OSHA looks like. Let's see what CMS looks like.
Well,
General, I'm sorry, go ahead.
Go ahead.
I was just going to say, Mr. Chief Justice, that I think the court, in approaching issues of statutory interpretation and looking at agencies' regulatory authority, has always started with the text that Congress enacted for purposes of understanding whether the agency has power to act. And the fact that there are other agencies here that likewise we think are empowered to act to protect America against what is happening in this country right now shouldn't diminish the force of the express statutory authorization
But I think
here.
The question is this. I mean, it is a rather deep, in a sense, deep question. Can you, or maybe you did, could the White House say, issue an order to all federal employees And what it says is every federal employee in any agency who has authority under a statute, which means all of them, to require those whom they regulate to insist that their employees be vaccinated, do it. Now, they can't legally tell you do it, but it's a strong policy. And that's what's happened. Now, I don't know the implications of that. I never thought of that. But I think that's what you're being asked, is that, if that's, and I don't know you ever thought of it. But I mean, has that happened?
I think it's incorrect to say that that is what is happening here. This policy clearly...
Yeah, but I mean, has that happened generally? Has that happened? Did somebody issue such an order?
Justice Breyer, standing before you today, I'm not sure that I can think of a precise historical example of that kind of order.
No, I mean, in this instance, your answer, I take it, is no. There is no such order.
That's right. I mean, certainly, I think that that throughout this nation...
I don't want to put words in your mouth. Don't tell me there isn't such an order if there is.
No, I'm not aware of any such order.
All right, or something like that. Okay. I have one other question for you, which is because I'm operating between two things. One is the merits, which might be difficult. I don't know. I'm not taking a view on that. But at least they're difficult and could take time. And the other is the question of the stay. Now, on the question of the stay, I read from research that we've done, but I don't know if it's right, that the argument was, what about the argument that they've made? One is that, well, if we issue a stay today, tomorrow, more people will stay home and things will get worse. See? That was one of their arguments. And the other, well, all right, what about that? That seemed to me to be the main one.
As I understand the argument, they're concerned about worker attrition with respect to that particular claim. Yeah. And the agency gave sustained attention to this very issue. It spanned several pages of the Federal Register. The agency looked at surveys that attempt to analyze how workers will respond. It looked at the real, on-the-ground, practical experience of companies that had imposed these kinds of mandates and found that there was substantial compliance levels and that the concern that workers would leave in droves was misplaced. And then the agency further emphasized that it had provided flexibility to employers to adopt a mask and test policy instead of a vaccination requirement, specifically because the employers are best positioned to understand their workforce and to know which of these options is going to ensure maximum compliance.
What about on the merits? I just have one other, which is on the merits. You've heard and you've read the argument on the other side that, look, what the OSHA could easily have done or should have done is go through industry by industry or groups of industries by groups of industries and say there's this here and there's that there. Instead, what they did is everybody over 100 employees, except for, and then they had a few exceptions, working alone, working at home, religious exemption. You can prove to us that you have some other thing that's just as good. You know, they went that way across industries instead of one by the other. That's one of their arguments. What would you say to that?
My response to that is that the Secretary here cited overwhelming scientific and medical evidence that the grave danger exists based on how this virus is transmitted anywhere people gather indoors together. And that applies to a lot of workplaces, but that just turns on the nature of how this virus is communicable between people. As Justice Kagan noted, often employees have little control over their work environments. They can't control whether they can socially distance, who they come into contact with, what precautions those people are taking, what ventilation systems exist. And ultimately, OSHA determined that anywhere there is a risk of indoor transmission, there is a grave danger to unvaccinated employees. Now, I take the point, as the Chief Justice's hypothetical focused on, I think Justice Barrett focused on this as well, that there are certain workplaces, factories, assembly lines, where the risk is even graver, where the danger and the chance of transmission is heightened. But I don't think that that in any sense calls into question the Secretary's determination that there is a baseline grave danger in any work site where that inside risk of transmission can occur.
General, can we, I'm sorry,